Well, good evening, everybody, and welcome to the Reader's Lecture for this evening. And we're delighted this evening to have Dr. Carmen Draghici, who's Reader of Law and Assistant Dean of Research at the City Law School in London, where she joined in 2009. She's also been an academic fellow of this for the last 3 years. And she's a member of the Practice Focus Centre for Child and Family Law Reform and has been since 2010. She is a specialist in human rights with a particular interest in the interpretation and application of the European Convention on Human Rights and Family and Child Law in England and Wales. And we're absolutely delighted that she's talking to us this evening about the absolute ban in the UK on assisted dying and the lessons we can learn from Canada, where the law was changed in 2016 to allow medical assistance in dying in limited circumstances. So I hope we're all going to enjoy an interesting topic, which has caused a lot of interest in the press over the years and in academic circles. And we're delighted to welcome Dr. Draghici this evening. Thank you.
Thank you, Master Reader, for the kind invitation to address the audience of the Inn tonight. The assisted suicide debate explores the law's response to a human tragedy, perhaps best illustrated by the high-profile case of Mr. Nicholson, a locked-in syndrome sufferer, asking for assistance to end what he perceived to be a painful, distressing, and undignified life. The predicament of Mr. Nicholson and others in similar situations stemmed from the absolute prohibition of acts assisting a person in committing suicide. In England and Wales, the blanket ban is established in Section 2(1) of the Suicide Act 1961, which makes encouraging and assisting another to commit suicide a criminal offense. The statute makes no provision for exceptions. However, under Section 2(4), the consent of the Director for Public Prosecutions is required to institute criminal proceedings against assisters. The first legal challenge to the blanket ban, heard by the House of Lords, as it then was brought by Mrs. Pretty, who wished to be assisted by her husband to travel to Dignitas in Switzerland without exposing him to the risk of being prosecuted. She complained that the DPP's failure to grant her husband proleptic immunity from prosecution breached a number of her rights under the European Convention on Human Rights. The House of Lords disagreed. First, Article 2 of the European Convention on Human Rights was found inapplicable, insofar as the right to life does not encompass a right to die. Article 3 of the Convention was similarly not engaged. The applicant's suffering stemmed from her illness and not from the DPP's decision not to accommodate her request. As regards Article 8, for the House of Lords, autonomy did not include the right to decide the timing or the manner of one's death. If, however, that provision was engaged, the interference was justified by the need to protect vulnerable persons induced to commit suicide. Finally, Article 9 was found to be inapplicable as well. There is no right to act upon every belief held. If Article 9 was engaged, the interference was justified on the same grounds as the Article 8 interference. Mrs. Pretty brought proceedings before the European Court of Human Rights, and in Strasbourg, her claims enjoyed moderate success. The court recalled that personal autonomy is an important principle underlying Article 8 guarantees, so much so that a person's ability to conduct their life in a manner of their choosing includes the pursuit of activities perceived by others as physically or morally harmful to them. For example, the refusal of life-sustaining treatment. Nevertheless, the restriction on Article 8 resulting from the blanket ban on assisted dying was within the respondent state's margin of appreciation, which is wide in end-of-life decision-making. It was also proportionate to the aim pursued, the protection of the vulnerable. Amongst other things, the court reasoned that there was flexibility for individual cases in that the DPP's consent to prosecution was required. However, the court did not consider the problems arising from the unpredictable exercise of discretion, later challenged by the Purdy case in the House of Lords. The Purdy case lamented the insufficient clarity of Section 2.4 of the Suicide Act as regards the DPP's exercise of discretion to prosecute. On this occasion, following the Strasbourg decision in Purdy, the House of Lords accepted that the prohibition on assisted dying engaged Article 8. That provision protected the right of terminally ill and severely disabled people to decide when or how to die. It further accepted that it was impossible to anticipate how prosecutorial discretion would be exercised in assisted suicide cases. Therefore, the interference was not in accordance with the law, which presupposes, as is known, the accessibility and foreseeability of the law. As a result of this judgment, in 2010, the DPP issued a policy for prosecutors in respect of cases of encouraging or assisting suicide. Prosecution is less likely to be required in the presence of several factors. The victim had reached a voluntary, settled, and informed decision to end their life. The suspect was motivated by compassion, had sought to dissuade the victim, and provided reluctant assistance. The acts were of minor assistance, and the suspect reported the suicide and cooperated with the police. The issue returned before the Supreme Court in 2014 with the Nicholson case. Mr. Nicholson and his co-appellants claimed that Section 2.1 of the Suicide Act was incompatible with the Human Rights Act 1998 and asked the court to issue a declaration to that effect. The Supreme Court majority disagreed on the following grounds. In the absence of an alternative scheme at hand, it was impossible to say with confidence that a permissive scheme could satisfactorily protect the lives of vulnerable individuals who would feel themselves a burden to their families. Secondly, the legislative process was better placed to assess controversial and complex questions. Finally, Parliament had to be afforded an opportunity to consider the matter in light of the case, as the issue was already before Parliament. And the legislator did consider the matter. Between 2014 and 2017, there were several unsuccessful attempts to pass an assisted dying bill for the terminally ill, largely owing to the lack of parliamentary time. In most cases, Parliament was prorogued after the formality of the first reading. The issue was ostensibly not treated as a priority. In 2017, the Conway case revived the matter in the courts. This case was different from the Nicholson case in several respects. It regarded a terminally ill patient, unlike Mr. Nicholson, and a patient still physically capable of the act ending his life. Also, an alternative legislative scheme was put forward based on 6-month prognosis and court authorization. The appeal was dismissed largely on 2 grounds. Parliament is better placed to assess such a highly contested policy issue and the conflicted evidence on the matter. Moreover, the court found itself restricted to considering the suitability of the precise scheme proposed. This approach arguably distorted the ordinary scope of judicial review. Instead of a human rights scrutiny of the status quo, the proceedings took the form of an examination of a legislative proposal. And for the court, the Conway scheme did not remove all the risks for the vulnerable and did not give proper weight to the sanctity of life principle. A further retreat from judicial review can be seen in more recent cases. In T, the High Court indicated that it was bound by the intervening Conway decision in the Court of Appeal. In the Newby case in 2019, the High Court questioned the justiciability of the issue altogether and the court's ability to deal with it. The courts lack legitimacy and expertise on moral as opposed to legal questions. There are some questions which plainly and simply cannot be resolved by a court, as no objective, single, correct answer can be said to exist. In Canada, the evolution of the law on assisted suicide has followed a radically different trajectory, both in the courts and in Parliament. The starting point was a blanket prohibition similar to the one currently in force in England and Wales. This was the result of 2 provisions in the Criminal Code. Section 241B, making it an offense to aid or abet a person in committing suicide, and Section 14, pursuant to which no person could consent to death being inflicted on them. A first challenge to the prohibition was brought before the Canadian Supreme Court in the Rodriguez case in 1993. By contrast with the initial response of English courts, the Canadian Supreme Court found that the ban engaged several rights protected by the Canadian Charter of Rights and Freedoms 1982, which is part of the Canadian Constitution and the functional equivalent of the Human Rights Act 1998 in the UK. In particular, Section 7 of the Charter protects everyone's right to life, liberty, and security of the person. The restriction was, however, found to be justified, first by the difficulty in creating effective safeguards to prevent abuse. Second, by the need to uphold respect for life and discourage those who might see themselves as a burden from committing suicide. All this changed with the landmark decision in the Carter case in 2015. In this case, the Canadian Supreme Court was prepared to find that the blanket ban amounted to an infringement of charter rights of competent adults who clearly consent to the termination of life, have a grievous and irremediable medical condition causing suffering that is intolerable to the individual. The analysis of the Canadian Supreme Court revolved around 3 violations of the Charter. First, the ban constituted indirect deprivation of life, in that it forced some individuals to take their lives prematurely for fear that they would be incapable of doing so when the suffering becomes intolerable. Secondly, the ban also amounted to a breach of the right to liberty. Patients were unable to make decisions concerning bodily integrity and medical care. This was compounded by the fact that the individual response to a grievous condition is critical to one's dignity and autonomy. Finally, the assisted dying ban constituted a breach of the right to the security of the person because individuals were left to endure intolerable suffering. Having established that there was an infringement, the court proceeded to check if it was in accordance with the principles of fundamental justice as required by Section 7 of the Charter. It found that the measure had a legitimate objective to protect vulnerable people who might be induced to commit suicide. But it was overbroad. It caught individuals outside the class it intended to protect. Nor was the measure saved by Section 1 of the Charter, according to which the rights guaranteed are subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. The prohibition was disproportionate to the objective, a regime that permitted suicide, but with proper safeguards could protect the vulnerable, by analogy with already existing medical procedures for informed consent to treatment and decisional capacity. So the measure was not minimally impairing. The court left the specific scheme of access to medical assistance in dying to Parliament. So it issued a declaration of invalidity of Section 241 and Section 14, suspended for 12 months to give Parliament an opportunity to cure the invalidity. In Carter versus Canada, number 2, in 2016, a 4-month extension was granted as a result of the interruption of legislative work caused by federal elections. The court held, however, that maintaining an unconstitutional law was an extraordinary step, and severe harm to individuals was caused by the extension. To mitigate the extension, the court therefore permitted individual exemptions during the extension of the suspension of invalidity. So those wishing to seek assistance in accordance with the Carter criteria could apply for relief in the Superior Court of their jurisdiction. At the end of the extension of the suspension of the invalidity in 2016, Parliament adopted an act to amend the criminal code in relation to medical assistance in dying, better known as Bill C-14. As a result, the new Section 2412, paragraph 1 of the criminal code allows medical assistance in dying for patients meeting the following eligibility criteria. They are adults entitled to health services in Canada who suffer from a grievous and irremediable medical condition, make a voluntary request for medical assistance in dying with no external pressure, and give informed consent after being advised of the available medical treatment and palliative care. Interestingly, the assessment of eligibility for physician-assisted dying is entrusted to 2 medical professionals rather than the courts. The notion of grievous and irremediable condition in this provision is defined in section 2412, paragraph 2, which lays down 4 criteria: serious and incurable illness or disability, advanced state of irreversible declining capability, physical or psychological suffering intolerable to the patient, which cannot be relieved by treatment acceptable to them, a noteworthy subjective test. In addition, the patient's natural death has become reasonably foreseeable. This last requirement was not in the Carter judgment. So the new law is more restrictive than the Supreme Court's judgment, but more liberal than the 6-month prognosis envisaged in the British assisted suicide bills reserved to the terminally ill. Unsurprisingly, perhaps, in 2015, in the Truchon case, this particular requirement was challenged, and the Quebec Superior Court ruled section 2412, paragraph 2, subparagraph D invalid, and suspended the invalidity for 6 months. The federal and Quebec governments decided not to appeal the judgment, but requested a further extension due to the COVID-19 pandemic's disruption of parliamentary proceedings. If or when it becomes law, the new Bill C7, an act to amend the criminal code, will repeal the section requiring that a person's natural death be reasonably foreseeable in order for them to be eligible. And it will introduce further safeguards in those cases, such as a longer period of assessment. Currently, the proposal is 90 days. This brief overview of the evolution of the law in the 2 jurisdictions suggests that the debates revealed similar doctrinal and pragmatic concerns. The Supreme Courts in both jurisdictions recognized that despite society's belief in the intrinsic value of life, self-determination, understood as privacy in the UK and liberty and security of the person in Canada, encompasses the right of an individual not to believe in the prevalence of the sanctity of life over a minimum quality of life. Consequently, sanctity of life ideology cannot constitute the basis for justifying the blanket ban. Recently, however, in the UK, the High Court and the Court of Appeal have taken a regressive approach in this respect. They found that the sanctity of life principle could justify an interference with privacy rights insofar as it is subsumed under the protection of morals aim contained in Article 8, paragraph 2 of the European Convention. In Conway, the Court of Appeal also attempted to rationalize the legality of withdrawal of life-saving treatment at the patient's request by contrast to the blanket ban on assisted dying. For the court, withdrawal of treatment allows causes present in the body to operate, whereas assisted dying presupposes introducing an external agency of death. This is a variation of the controversial distinction between act and omission, killing the patient as opposed to letting the patient die. And in my judgment, it is equally unconvincing. The same motivation, compassionate, is present in both, ending suffering. The intention is the same, to implement the patient's decision. The patient retains moral agency. And the same consequence occurs in both situations, the death of the patient. It is also often materially difficult to differentiate between an act, pulling out the feeding tube, and an omission, not supplying nutrients down the tube. Either way, the patient dies, and with the doctor's foreknowledge. That said, the debate in both jurisdictions revolved primarily around pragmatic concerns. The so-called slippery slope argument, it was readily accepted in both courts that a permissive regime might induce certain individuals to commit suicide, either through indirect coercion or because they feel that they are a burden on their families. The crux of the debate lies not in the existence of the ban per se, but in the complete absence of any opportunity for exceptional authorization. So the question was whether it is necessary to address vulnerability through a blanket ban, and whose burden it was to prove that no lesser measures were adequate. According to the Carter decision, risks cannot be merely speculative, and the onus is on the government to demonstrate that the absolute ban is not arbitrary, overbroad, or grossly disproportionate. In Nicholson, the allegation of risks was presumed true, and so was the assumption that the complete ban is necessary. Instead of requiring the government to prove that no lesser measure is available, the burden was placed on the appellants to show that the ban can be relaxed without risks of error or abuse. Conway indicated that it was the appellant's burden to submit a cogent alternative, and it was not satisfactory to say that Parliament can work out the details. The expectation placed on the individual litigant by the Court of Appeal was, to my mind, rather astonishing. The court's approaches in the UK and Canada also differed on whether effective safeguards against error and abuse can be established. The unanimous Carter Court and the Nicholson minority answered this question in the affirmative based on existing procedures for ascertaining consent and decisional capacity. The safeguards were deferred to Parliament in light of the experience in other jurisdictions. The Nicholson majority was, by contrast, not sure that effective safeguards were feasible. With no specific scheme available, a complete ban was justified as a matter of precautionary approach. In Conway, where a scheme was available, the court was not satisfied that the proposed scheme could eliminate all risks, and consequently, it upheld the ban. Two issues were of particular importance in Conway. First, courts cannot successfully determine competence. This view stands in contrast with Carter number 2. For the Canadian Supreme Court, judicial authorization during the extension of the suspension of invalidity constituted an effective safeguard against risks. The other problem for the Conway Court was the lack of resources for the court's inquisitorial role. The court did not, however, query the effectiveness of the DPP's investigation after the patient is assisted to die. The case-by-case retrospective prosecutorial assessment of assistance, as opposed to anticipatory dispensation, has often been invoked as evidence of proportionality of the measure. In Nicholson, the court indicated that the DPP practice comes close to tolerating assistance in dying. In Conway, the court said that the possibility of prosecution is not a high risk. In Canada, before the 2016 reform, there was a similar permissive trend resulting from prosecutorial and judicial discretion. What this means is that administrative law has accepted assistance as morally and legally permissible in certain circumstances. This is highly problematic. It negates the need for the absolute ban. Clearly, there is room for departure. It discredits the logical connection between the purpose and the effects of the absolute prohibition. It creates a conflict between primary legislation and prosecutorial practice. It is indeed undesirable for courts to endorse a corrective tool that goes against the statute, rather than inviting Parliament to carve a legislative exception, however narrow. Certainty of law is not well served by this approach. Also, individuals are assisted without prior review. This offers less protection for vulnerable individuals than anticipatory authorization. Also, less evidence is available for the retrospective assessment of the circumstances and of genuine consent. So all this goes against the aim of the statute. In addition to the specific issue of assisted suicide, the aforementioned litigation in Canada and the UK has raised the same fundamental constitutional question. How is the legal system structured to decide sensitive ethical matters? Are they the exclusive remit of Parliament, or is there any role for the judiciary? According to Carter, courts can determine compatibility with charter rights regardless of the subject matter of the dispute. Conversely, the UK courts refused to issue a Section 4 declaration in respect of Section 2 of the Suicide Act, either because the dispute was found not to be justiciable or out of deference to parliamentary sovereignty. According to Pretty, the court is not able to make ethical and moral decisions because it is not a legislative body. In Nicholson, consideration of sensitive issues of social policy and moral judgment were found by several justices to be better left to Parliament. For some of the justices, the law might have been incompatible, but it was inappropriate for the court to decide before giving Parliament an opportunity to consider its position in light of the judgment. Only 2 justices were prepared to issue a Section 4 declaration in Nicholson. As Lady Hale indicated, the basis for that was that when issuing a declaration of incompatibility, courts do precisely what the Human Rights Act empowered them to do, namely to remit an issue to Parliament for a political decision, informed by the professional opinion of the judges, which includes the option of leaving the impugned legislation unchanged. This approach of the UK courts is not unproblematic. First, most Section 4 declarations have arisen in morally sensitive issues. Transgender persons' right to recognition and to marriage according to the acquired gender, posthumous fatherhood, terrorist suspects' rights. There is also no rule in the Human Rights Act that a Section 4 declaration cannot be issued while the matter is before Parliament, as suggested in Nicholson and in Conway. On the contrary, it would seem that the highest court's legal opinion is a welcome contribution to the debates. A formal record of incompatibility is also appropriate, as the House of Lords held in Ballinger, although Parliament had already announced its intention to change the law. Importantly, there is no rule in Section 4 that a fully fledged, viable legislative scheme must be available to the courts before issuing a declaration. The exact remedy is left to Parliament. Courts merely signal the incompatibility. For instance, in Ballinger, neither the court nor the applicant had to provide a detailed scheme on eligibility for a gender recognition certificate. For example, for how many years the person had to live socially in the new gender. The impact of gender reassignment on existing marriages, on parenthood of children born before gender reassignment, so on and so forth. That scheme was devised by Parliament in the Gender Recognition Act 2004. If anything, for courts to choose the correct alternative would be out of step with the separation of powers. There is also an unjustified reluctance to use Section 4 insofar as encroaching upon Parliament's prerogatives. Actually, declaratory relief under Section 4 is less intrusive than Section 3 interpretation. It does not change the law. It does not override statutory language. It gives Parliament an opportunity to tailor the law. It does not invalidate the law. Unlike Canadian declarations of invalidity, under the Canadian Constitution, Canadian courts have actual strike down powers. Some judges may feel that Section 4 is a more powerful instrument in practice than under the statute due to the history of compliance with Section 4 declarations. However, as the prisoners' voting rights case shows, government and Parliament may choose not to act upon a Section 4 declaration. Finally, the margin of appreciation left by Strasbourg authorities was arguably misconstrued in the UK as parliamentary discretion. Although the European Court of Human Rights found that there is no consensus on end-of-life decision-making in Europe, and hence allowed a wide margin of appreciation, domestic courts can go further. A Section 4 declaration of incompatibility with the Human Rights Act is not precluded by Strasbourg's acceptance of both blanket bans and permissive regimes as compatible with the Convention. As the House of Lords acknowledged in Recipients, Adoption Unmarried Couple, incompatibility with the Human Rights Act can occur even where there is no breach of the European Convention at the international level. A stricter standard of judicial review is possible in domestic courts, unencumbered by the subsidiarity of international supervision and the need for European consensus. Domestically, that margin of appreciation left by Strasbourg is shared by all branches. In the Gaiden and Godin-Mendoza case, courts used Section 3 of the Human Rights Act to offer a more generous interpretation of Article 8 to include same-sex partners before the Strasbourg court did. In Rizia Child, a Section 4 declaration was issued in relation to the non-eligibility of single applicants for parental orders following surrogacy arrangements, even though surrogacy is an area of wide state discretion. The Nicholson Court, however, was divided on the domestic exercise of the margin left by Strasbourg for some judges, the decision falls to be made by Parliament domestically. Only some of the justices held that both the legislature and the judiciary have a potential role in assessing whether the law is domestically compatible with the Human Rights Act. In light of the foregoing considerations, it appears that Canadian law better reconciles competing interests. On the one hand, the patient's autonomy, the right to decide for themselves in matters regarding medical care and bodily integrity, their right to life and security of the person. On the other hand, societal interests. First, ethical concerns over devaluing life. Life is intrinsically valuable and it should never be intentionally brought to an end. The Canadian compromise in respect of ethical concerns lies in a general prohibition on assistance in dying, mitigated by exceptional authorization in limited circumstances. Also, Canadian law accepts the deferral of ethical judgment over sanctity versus quality of life to private opinion. Whether premature death is preferable to a critically impoverished quality of life is left to the patient. As regards practical concerns, the protection of the vulnerable, the fear of a slippery slope, abusive or erroneous application of the law. The Canadian response was implementation of permissive legislation accompanied by safeguards against error and abuse. The credibility of this response rests upon the fact that doctors are already deemed able to assess competence to give consent to medical treatment, including withdrawal of life-saving treatment. And courts are deemed able to assess mental competence where this is in dispute. A case-by-case decision-making mechanism better complies with the requirements of proportionality or minimal impairment when compared to a bright line rule. Bright line rules tend to be disproportionate, overbroad, or present no rational connection. And this seems to be definitely the case in relation to the blanket ban on physician-assisted dying. First, the restriction affects unintended recipients. The blanket ban affects persons who are not vulnerable, competent adults not pressurized by their families, who are not the intended target of the law. At the same time, the restriction does not help intended recipients. It does not protect vulnerable individuals pressurized by families who are physically able to commit suicide. For example, who can travel abroad to a permissive jurisdiction unaided, or who can disconnect a life support machine or refuse life-saving treatment. The bar arbitrarily catches those who are completely paralyzed or impecunious, regardless of issues of vulnerability. It can be said that the blanket ban chooses between rather than reconciling competing interests. It makes no concession to autonomy rights. The retrospective persecutorial assessment is not a valid substitute for prior case-by-case determination. It is inconsistent with the foreseeability of law principle. It cannot offer protection because it occurs after effect. It is less able to ascertain consent due to evidentiary difficulties after the death of the patient, and it raises equality issues. The solution of traveling to Dignitas presupposes reliance on willing relatives. and traveling abroad for medical assistance. Medical professionals are unlikely to risk criminal liability, and patients cannot choose to die at home. Also, the retrospective assessment by the prosecutor does not avoid the stigma of criminality for assisters, even if they are not prosecuted. Canadian assisted dying law, when compared to its UK counterpart, has demonstrated both a superior substantive scheme and a better understanding of the court's constitutional role in monitoring human rights compliance. First, a scheme based on prior authorization following medical assessment of eligibility for assistance in dying is more appropriate on several grounds. First, it aligns assisted dying regulation with other areas of medical law. In particular, informed consent to treatment or refusal or withdrawal of treatment. Medical law recognizes competent adults' right to refuse or to request the withdrawal of life-sustaining treatment for no reason at all. They may not be forcefully administered treatment, even where failure to treat results in death. The sanctity of life justification and the absolute bar on assisted dying are therefore inconsistent with this well-established principle of medical law. Another area of interest is termination of treatment for children in life and death cases. Parents and courts may authorize the termination of life-sustaining treatment for children afflicted by extreme incurable illnesses. The law recognizes that it is not always in the best interests of the child to prolong life. The recent cases of Charlie Gard and Alfie Evans come to mind. Finally, the area of involuntary euthanasia for patients in permanent vegetative state. The law accepts that there is a minimum quality of life below which the individual takes no enjoyment and does not participate in life. As Lord Neuberger noted in Nicholson, active euthanasia is a more extreme moral step than assisted suicide because it involves deciding for a third party. Exceptional authorization of assisted dying also promotes the preeminence of self-determination over collective beliefs and paternalistic concerns. And it ensures tolerance of different subjective views and individual choices. Finally, it offers humane assistance in ending prolonged suffering or preventing a distressing death, like death by suffocation, or a premature or traumatic self-inflicted death, for example, through self-starvation, which is something unsuccessful litigants have proceeded to. But the Canadian court has also shown better understanding of courts' constitutional role in monitoring human rights compliance. The Canadian approach has promoted a dialogue between courts and Parliament, seen as co-participants in the democratic lawmaking process. It has accepted the justiciability of sensitive, morals-laden areas, which seems to be the better view insofar as human rights are indistinguishable from underlying values. The Canadian courts have also acknowledged the role of the judiciary as a corrective to majoritarian deliberation and legislative inertia. Meanwhile, UK reform bills failed mainly as a result of lack of parliamentary time. The rights of those few individuals with catastrophic illnesses who desperately seek a peaceful, medically assisted, controlled death have not been a national priority, and courts did not embrace their agenda-setting role. Overall, the Canadian experience therefore demonstrated the profound role of courts in upholding human rights, where an issue affects a small sector of the population, but with grave consequences. The courts have the ability to place it firmly on the legislative agenda. I expand further on these issues in a book titled British and Canadian Public Law in Comparative Perspective, a book edited by Ian Loveland, which will be launched by Hard Publishing in May, should anyone have a particular interest in this topic. Thank you very much for your attention, and I am looking forward to any questions or comments.
Well, first of all, I'd like to thank Dr. Draghici for a really fascinating view, both of our own law in this area, but also on Commonwealth Day, how we can learn from other jurisdictions still. Now, if you'd like to ask Dr. Draghici any questions, if you'd like to put those on the chat bar. At the moment, I haven't seen any. Does anybody have any questions that they would like to ask?
There is a question in the Q&A function, Master Reader.
All right, thank you. Yes, somebody's asking here anonymously in the news today about how there have been notable instances where Do Not Resuscitate was written into disabled people's charts without their knowledge or consent. And similarly, women have been encouraged to abort and in some cases pressurized to abort potentially disabled children. So how can doctors really be deemed capable of assessing free and informed consent? And how would you ensure that a license to kill wasn't the result of a removal on a ban on assisted suicide?
Yes, thank you very much for that question. Well, this is precisely the problem, how to avoid misuse of the ability to request assistance in dying. But the response to that is that it should not be the court's mission to try to find a well-articulated scheme. This is the remit of Parliament. What courts do have the authority to say is that the law is currently inconsistent. How do you know that a person who requests the withdrawal of life support does so without being pressurized or without any subconscious guilt, feeling a burden on the family? That is the problem. If we deem doctors and courts capable of gauging consent in those cases, then certainly the same should apply to medical assistance in dying. There is an inconsistency currently in medical law which needs to be addressed, and this is something that courts had the ability to draw Parliament's attention to. The other example mentioned was women being pressurized into aborting fetuses with disabilities as a result of the scan. Again, Article 8 rights should not be limited on the assumption that there will be abuse. The focus needs to be on how to assess authentic, genuine consent. And that can be done through, for example, counseling, through an interview of the prospective patient who wants to terminate an abortion. This is already routinely done in the context of assisted procreation, for example. Counseling is mandatory before someone can be given treatment under the Human Fertilization Act. Procedures do exist. My purpose today is, I'm not a medical lawyer, and it is not within my competence to put forward a scheme. This is not the purpose of my talk tonight. The purpose of the talk is simply to draw attention to the fact that there are inconsistencies in the law and that a blanket ban may be the safest way out. But in doing so, we sacrifice the right of those people who simply find their existence intolerable and undignified. And those people's rights deserve more careful consideration.
Can I just go on from there? Because there's a question which follows on from Ilona Duro, who said, providing that the patient is competent and not being coerced in any way, do you see the law eventually recognising the rising number of elderly patients who are simply tired of life, particularly those who aren't suffering from a medical condition or illness?
Well, again, this is something for Parliament to fine-tune. For example, we have seen in the Canadian experience that a medical condition is required. Someone who simply has lost the will to live would not qualify under the Canadian law. It is not for me to say that that is the best option. I am simply drawing attention to the fact that currently there are certain limits. For example, Canadian law, even if it's reformed to remove the requirement for the foreseeability of the death, still would not allow, for example, assisted death only in cases of mental suffering as opposed to physical suffering. So there are a lot of things to consider here, but the blanket ban only ensures one certainty, that certain people's rights are infringed. That's the only certainty. So the need for safeguards is definitely a critical issue, but not trying to explore alternatives and just perpetuating the ban on the basis that it is the most simple solution is not the answer that best reconciles competing rights, the rights of the vulnerable, but also the rights of those who have determined that they do not wish to live with the quality of life that they have.
And does the Canadian legislation, this is a question from Tina Jones, address assisted dying outside of assistance by a medical practitioner, for example, assistance by a family member?
Well, in Canada, obviously, the scheme provides for medical assistance in dying. There is no reference to different kinds of assistance. I suppose in the UK, the assistance of a family member has been the only remedy, insofar as traveling abroad is the only option. Otherwise, patients risk a botched attempt, which may leave them worse off. But as I said before, traveling abroad to a permissive jurisdiction is not a satisfactory solution on so many levels. First, if someone doesn't have willing relatives, this is not an option for them, like Martin in the Nicholson case. If they don't have the means to do so, again, this is not an option for them. So they are left with self-starvation, or they are left with some violent method of taking their own life. There's also the problem of the law forcing people to consider taking their life earlier than they would want to, for fear that when they actually do feel that they want to, they no longer have the capacity to do so unaided.
Well, I think that covers, that last answer covers the question which Thaddeus Manus asked. How does somebody who's terminally ill have the capacity to decide to end their life, and also perhaps the physical ability to do so?
Right. Well, in the UK, physical ability could mean something as simply making arrangements with Dignitas and getting on a plane. Yeah. If someone else does that, a member of the family, technically they're caught by Section 2(1) of the Suicide Act. Technically, they risk criminal prosecution. The fact that they may not happen in practice, or that it's very unlikely in practice, is not satisfactory for the peace of mind of the person who asks, or the assister. The likelihood of non-prosecution is very different from the reassurance of prior authorization. So this is why I think our law should also be reviewed, and some form of prior authorization should be sought, whether it is by medical professionals, as in Canada, or authorization in the courts, which incidentally was the case in Canada between the Carter judgment and the adoption of the new law after the second suspension of invalidity. And I have looked at the case law of people who wanted to be assisted and requested judicial authorization, and they were all well-educated individuals. They were well off. Their family had tried to dissuade them. They had looked into assisted diet option for sometimes 2 years prior to the case. And there was no doubt in the judge's mind that they had expressed free and informed consent. And it is entirely possible to ascertain consent. If we challenge that assumption for assisted dying, we have to challenge it for all medical treatment, including the refusal of treatment that would save life, including the refusal or the request to discontinue treatment. And there's also another paradox in the law. There seems to be no moral unease with letting the patient die slowly by disconnecting them from a machine. But a pain-free death through medication is seen as morally unacceptable. Similarly, we think that someone who wishes to receive medication to die peacefully is committing suicide, but someone who requests the withdrawal of life support is not committing suicide. They are refusing treatment, whereas obviously the predictable outcome is the same. Obviously, the doctors would be assisting the patients to commit suicide when they disconnected the machine, wouldn't they? So there are so many inconsistencies that suggest that our law is not satisfactory.
Thank you. And just a question about what the effect of the change in the law in Canada has been. Has there been a significant additional take-up in Canada following the change in the law?
That is an interesting question, and I have to say I haven't looked at any statistics to see if that has been the case. This is something that I could certainly do, and that's quite interesting to look at the numbers. But as I said before, even before the law was changed, the practice in Canada was, as in the UK, to tolerate assistance in dying in situations where it was obvious that the assister had acted as a result of compassion. So I don't think the numbers necessarily will be considerably higher. Also, already since 2016, this has been possible by way of individual exemption in courts. So I imagine if you look at the statistics, you'll have to already look at a few years back, because this has been in practice possible, not by virtue of a legislative basis, but by virtue of the dispensation that the Supreme Court afforded.
Thank you. And just, I think finally, what I'm going to ask is to group two questions together, which are about Article 2 rights. Or first of all, to what extent do you think that the provided by law requirement in Article 2 restricts the ability of the judiciary to consider assisted dying, when its counterpart in the Canadian Charter refers to principles of fundamental justice, which appear to permit more leeway by the courts? And secondly, just together with that, do you think that the UK court's approach to assisted dying in the light of Article 8 rights rather than Articles 2 or 3 is right?
Okay, thank you very much for that. These are two very interesting questions. Required by law obviously presupposes a legal basis. But if the UK courts issue a declaration of invalidity, that does not change the law. That simply invites Parliament to revisit the law, and there will be a legislative basis for assistance in dying. Actually, what happens currently is that people are assisted. Administrative law tolerates the assistance, but there is no legal basis for that. If anything, what happens at present is not exactly supported by a legislative basis. A legislative exception should be enshrined in the statute in order for assistance to occur legitimately. The difficulty with what happens at present is also that clearly law and society acknowledge that assistance is appropriate in some circumstances. So there is a divorce between the law and what society deems morally appropriate. This is highly problematic. The law should be aligned with the moral values of society. So yes, of course, required by law. Once the courts signal to Parliament the fact that there is an inconsistency there in the law, that some people's Article 8 rights are not adequately protected, then it is for Parliament to issue an exception, again, narrowly defined, accompanied by safeguards, but more in line with what we already think about consent to treatment and decisional capacity. The second question was about the basis for deciding the case. Well, under the Canadian Charter, there is no right to privacy per se. There is no equivalent to Article 8 in that sense, which is why the decision was made primarily under Section 7, which protects life and personal integrity. But in the UK, obviously, the main provision would be Article 8, which protects the right to bodily self-determination, the right to make decisions for oneself, and the right to live one's life in accordance with one's own philosophical beliefs. Again, decriminalizing assistance in certain cases would not be sending a message that the state takes a certain view on the debate sanctity versus quality of life. It would simply be a recognition that this is a matter for the individual. Everyone should be able to make that decision for themselves. But I think Articles 2, 3, and 14 are also very important here. The claim was made in the Newby case, actually. It was a new claim based on Article 2. In that case, the person was still able to end their own life, but they didn't want to do so until they decided that the quality of life has diminished to the extent that death is preferable. But because at some point you might lose the capacity to do so unaided, you as the patient who goes through a process of degenerative disease might be compelled to do so earlier, whilst you can still travel to Dignitas, for example, whilst you can still disconnect the tube. This is wrong, because the prohibition has the immediate effect, as the Canadian court recognized, of inducing people to take their own life prematurely. Article 3 is also very important because this is subjecting people to ill treatment. Autonomy means not just refraining from doing something. Autonomy also means sometimes positive demands. A person who is paralyzed from the neck down, in order to exercise the same right that someone else has, may need external assistance. This is why I think these are importantly discrimination cases as well. Now, under the Canadian Charter, the submission was made because Section 15 was invoked, non-discrimination of disabled people who cannot act autonomously. And that was not addressed on the basis that under other provisions, the Canadian court was already capable of finding that there was an infringement. I think this is worth looking at. In the UK, Article 8, taken together with Article 14, suggests that individuals who cannot travel independently, who don't have the means to go abroad to receive assistance where that is available, are really not placed on an equal footing with those who can exercise the right to end their life. And let's not forget that the law has decriminalized suicide for quite some time. So this is something that able-bodied individuals can do as long as they retain the ability, that minimum ability to do so. This is why I was saying earlier that the bar catches a very, very narrow category of persons. Persons like Mrs. Pretty or Mr. Nicholson, who depend on a willing other to travel, or on a doctor who is not going to risk 14 years imprisonment to assist someone unrelated to them here. And also someone who doesn't have the financial means to travel to ensure the repatriation of the body. There are so many complications when it comes to using services in Switzerland or elsewhere. So it is also a non-discrimination issue. So Article 14 is as much at stake as Article 8, Article 2, and Article 3.
Thank you. And I think just finally that there's a question from Michael Wall asking whether you're able to say more about why you think the two areas of law, well, the law has diverged in the UK and the Canadian jurisdiction to this extent.
This is a very, very good question. I think part of it is that the Canadian courts have taken a more flexible approach to precedents. In Carter, the first instance judge found that it was not bound by the Rodriguez precedents decided in 1993, insofar as moral opinion had evolved, the interpretation of what is a legitimate restriction, what's overbroad, had evolved, and therefore, in the presence of changes in law and in society, first instance judges can reopen the issue. And this is very important because in the UK, there is a certain inequality of arms between the individual litigant and the respondent public authority. The respondent public authority can go all the way up to the Supreme Court. The individual may not have the resources to do so, and very often they may just drop the case. So the case may not even be heard by the court that has the ability to depart from precedent. And we've seen that domestically, we've seen in Newby and Conway, there is a very strict adherence to precedent. This is one issue. The other issue is definitely deference to Parliament. Although I said Section 4 doesn't change the law, there is, it seems to me, a perception within the judiciary that actually the executive will feel bound to act upon the Section 4 declaration. But this is not in the scheme of the Human Rights Act. And indeed, it sounds counterintuitive for Parliament to have wanted courts to draw attention to trivial issues. Indeed, trivial issues are likely to be resolved without having to breach human rights. So I think this position on Section 4 of the Human Rights Act deserves revisiting. And again, I was mentioning the prisoners' voting rights case. It shows perfectly well that yes, there is a tendency to follow Section 4 declarations, but there is no compulsion to do so. And I would add something else. In Canada, before the Supreme Court judgment in Carter, there were 16 bills in Parliament to review the legislation. None of those were government-sponsored bills. They're all private members' bills. They were all allocated very little time. This is exactly what I see happening in the UK. The matter is not treated as a priority. And both in the European Court of Human Rights jurisprudence and in the Canadian jurisprudence, courts have insisted that it doesn't matter how many persons suffer because of an unjust law. If the law is unjust, time must be made to revisit it.
Well, thank you very much again. It's been an absolutely fascinating lecture, and I'm sure we're all very grateful that you've answered our questions too. And I'm sure we'll look forward to being able to see each other in person, because at this point, I'm sure that we would have all given you a round of applause, which we obviously can't do on screen. But thank you very much indeed.
Thank you very much. Thank you very much for chairing, and thanks everyone for the very stimulating questions. Thank you.